Hey everybody, Arizona attorney David Wilson here, and in this video I want to talk to you about spousal maintenance. Now, most people know spousal maintenance more commonly as alimony, but it's technically speaking, it's referred to as spousal maintenance in the state of Arizona. So when I say that, you can use those terms interchangeably. If we're talking about alimony, same thing as spousal maintenance. Now, when you're looking at spousal maintenance, legally speaking, there's a two-tiered test that you're going to be looking at. First question you're looking at is whether or not someone is eligible for spousal maintenance. And if they are eligible, second question is how much do they get and for how long do they get it? Now, these are governed by statute in Arizona. There's a rule that has a series of tests that you're going to be looking at. The eligibility question is dependent on four different factors. One is that I'm looking off screen because I have them written over here. One is the spouse lacks sufficient property, including property apportioned to the spouse, to provide for that spouse's reasonable needs. In other words, the person that's asking for spousal maintenance just does not have enough to survive, and they need something from the other party. Another one is unable to be self-sufficient through appropriate employment, or is the custodian of a child whose age or condition is such that the custodian should not be required to seek employment outside the home, or lacks earning ability in the labor market adequate to be self-sufficient. So that one essentially boils down to you just cannot get a job to keep yourself afloat, or you have to stay home to care for somebody that can't even go to school or take care of themselves. So you've got an infant that you're caring for and you don't have any job skills, that kind of thing. Third one is contributed to the educational opportunities of the other spouse. The theory there is if you put somebody through, say, med school, law school, put them through got their bachelor's and they're off as an engineer or something, where they're making a whole bunch of money, if you were supporting them through that whole time, and then all of a sudden they say, you know what, screw you, I'm out of here, and then they get the divorce, you should be compensated for that. That's the theory there. So that's one of the eligibility prongs. Then the last one is there was a marriage of long duration and the person seeking maintenance is of an age that may preclude the possibility of gaining employment adequate to be self-sufficient. The prototypical example I think of there is the 80-year-old housewife that hasn't worked since she was 18, and there's no way she's going to go out and just get a job. So in that situation, the other party is going to have to support them. Now, there isn't any specific reference to gender in any of this. A lot of people assume that it's the guy is going to have to pay the girl just because. You have to look at those factors. And if you're satisfying those factors, then you're going to pass on to the second test. Now, the second test has quite a few more factors that you're looking at. What they essentially boil down to is how much does the person that's eligible need to stay afloat, and how much can the other person pay out? That's, in a nutshell, the equation. It's a little more complex than that, but that's really what you're looking at. So a lot of times when you're arguing about spousal maintenance, it is essentially just a question of one side saying, I need this much money to stay afloat, to pay my bills, to survive. This is what I'm used to living on, that sort of thing. And that other person has the ability to pay it. Meanwhile, the other side is going to be saying, you don't need that much to stay alive, and even if you did, I couldn't afford that. Those are essentially the two arguments that are going to be popping up. One thing that I want to make very clear to people, and this is something I say all the time, is that spousal maintenance is probably, in my opinion, the single most subjective thing in the whole of family law. It is all over the map in terms of where you're getting rulings, and that's unfortunately by design. The statute is very subjective in the way that it's interpreted, and you can have one judge that sees something completely different from the way another judge does. So anytime you've got these spousal maintenance situations, if you can get to an agreement on things, and it's something that is feasible and you can live with, you're probably 10 steps ahead, because if you go to trial on this, you have no idea what's going to happen. And I've seen judges with very similar fact patterns come out in dramatically different places. So, and that's not by any fault of the judges. They're coming in with whatever perspective they have, and they have an inherently subjective statute that's just going to be ruled that way. So if you can get to an agreement, do so on spousal maintenance. Now, it has to be something sustainable, it has to be something reasonable, but get there. Now, if you can't get to those sustainable, reasonable things, you're going to have to go litigate it. And if you do, you're going to follow that test. And that's what the judge has to follow, is that, are you eligible? And if so, how much and for how long?